before the Honorable, the Justices of the Appeals Court, now sitting out of Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am William Meade. With me on my right is Justice Massing, and on my left is Justice Sachs. We'll be the panel for all the cases today. If you haven't been here before, nothing has changed. Each side gets 15 minutes. You needn't use all your time. We've read everything. We do not entertain rebuttal. With that, I'll call the first case, 23P number 4, Commonwealth versus THELEMAQUE. Ms. Miles.
Good morning, Your Honors. Mary Miles for the appellant, STECA THELEMAQUE. I argue in this case that the trial court improperly allowed 3 witnesses to identify my client for the first time at trial. 2 of the police officers had little or no prior familiarity with my client. The one civilian witness, while she did testify that she had purchased heroin from my client for a few months, there had been 3 intervening years between this alleged heroin transaction and trial. I would argue that given her cooperation agreement and that 3 years, and that she had no prior or no contact with my client between those 3 years, there was no reason for the Commonwealth not to have her undergo a non-suggestive out-of-court
Does the case law delineate or qualify how familiar someone must be to be familiar?
So I think we just have case by cases, and I think the Fielding case said extensive and intensive is I think the language they use. Obviously, Creighton uses someone who would be, a victim of domestic violence. Obviously, they have, extensive and intensive interaction with the defendant. In this case, with the 2 police officers, while defense counsel did try at voir dire, Capasso never met or interacted or spoke with my client, and he had only surveilled him, couldn't really tell us when he had surveilled him, but did tell us it had been at the North Street housing projects. Cicerone had met my client maybe once or twice prior to 2015, but couldn't really give any more detail other than that. He also testified that he knew of my client, through secondhand knowledge of the narcotics unit of Somerville PD. And
Capasso said that he'd seen him a dozen times conducting surveillance of that same property.
Correct.
That's pretty significant.
Well, I don't know if that is significant. He never really had an interaction. We don't really know where he was when he surveilled him, how long he surveilled him for. We just know that he saw this person that someone identified as STECA. He never had a conversation with him. He never interacted with him.
He was as close as 10 feet when he witnessed the hand-to-hand sale.
Correct. So that would be him testifying based off of his recollection of the events, right? And so Creighton, I think, and Ortiz is really instructive in this case, says that because the suggestive identification of identifying someone in court is so high that even outside of just eyewitnessing the crime, there should be some sort of prior familiarity. And to your point, Justice Meade, the Ortiz case talks about that one officer who I think they said he was in the car with the defendant for like 3 or 4 minutes, or for an extended, maybe it was 15 minutes, an extended period of time. But the SJC still found that because of his lack of prior familiarity, except with being involved in the investigation, that was improper.
What was the case? You mentioned a case at the beginning. I think you said Fielding.
It was a 2017 case, and I believe my sister quoted it. It just basically says that, given that the defendant and the victim had spoken for about half an hour, that that was an extensive and intensive opportunity for the eyewitness to identify the defendant at trial, and there was no need to do a prior out-of-court non-suggestive identification.
And sort of a follow-up to Justice Meade's question about how familiar has to be. This is we review for abuse of discretion, right?
Correct.
So okay, does that inform how familiar has to be?
Well, I think so. The Ortiz case came out after this trial, so I think Ortiz really said that just because an officer is involved in the investigation and really doesn't mean that he has enough prior familiarity to be able to identify the defendant at trial. They talk about how an arresting officer or an officer, if he's testifying as an arresting officer, is merely confirming that the person on trial is the person who was arrested and whose conduct is at issue. When you're talking about an eyewitness who was not the arresting officer, that he's testing merely as a civilian. And I'm not really aware of any case that says that if I had seen someone on the street, a couple dozen times, I can then ID them 3 years later at trial. So I think, perhaps we get caught up in that he's an officer, but since he's not testifying that he arrested this person or this is the person that we booked, he's merely testifying that I saw this person do X. And I don't really know if we would allow a civilian witness to say that.
After he's detained at the airport, Cicerone goes to the airport and picks him up.
Correct.
So that's an arrest.
Correct. But Cicerone didn't identify him that way. Cicerone identified him as someone he saw at the housing projects. He didn't say, this is the person that I arrested or the state police.
Because Cicerone may not be familiar with the case law that talks about being the arresting officer. That doesn't mean he's not familiar.
Yeah, but the Commonwealth is.
He spoke with him before.
Yeah, correct. So Cicerone is the officer who said we spoke with him maybe once or twice. He couldn't give any details about that. But he still didn't identify my client that way. He didn't say I arrested him at Logan. He identified him as the person leaving the housing projects and engaging in these hand-to-hand interactions. I would also say that, there was a 3.5-hour time period. There's a difference between, someone arresting someone, seeing a drug transaction, then arresting them immediately. There's a continuum there.
Isn't that fodder for cross-examination? I mean, doesn't that go to the weight of the identification, not its admissibility? And
that's what that's really why the trial court allowed that.
So the answer is yes.
Well, but then I would point this court's attention to Creighton really talks about that, right? It talks about that, a lot of other jurisdictions say that this is an issue for cross-examination, but sometimes cross-examination cannot address the undue weight of a suggestive in-court identification.
And that's why the judge had voir dire and exercises the discretion to admit it.
Yes, correct. I would then say that he wasn't given the SJC's analysis in Ortiz as to why an arresting officer who's also an eyewitness is testifying as an arresting officer, not necessarily I saw this person do X.
There's something, there were 2 charges and 2 subsequent offender charges.
Correct.
One had to do with Ms. Brown and one had to do with Ms. Cohen, is that right?
Correct.
And they were bifurcated, only one was tried?
Yeah, so it was very odd. Ms. Brown was tried first, and so, but they allowed.
So the Brown was tried first, that's
correct. And they allowed Ms. Cohen's testimony in as a prior bad act, and then based off the same evidence, the judge, I believe, found guilty on Cohen, correct.
So, I mean, it seems to me of all the 3 that Ms. Brown's the one who has the most familiarity. She bought drugs from him in the past.
I don't disagree with that. I think that is definitely, that would be the much more harder identification to argue that was improper. I will say that given her voir dire testimony, she's pretty clear that she doesn't remember a lot from that day, and she keeps on saying on cross-examination and to the prosecutor, this is 3 years ago, I don't remember. And she did say she purchased heroin from my client for a few months, but that she had no interaction with him from that last date in November to the date of trial. So, I just don't see that there's no reason for the Commonwealth not to have done an out-of-court non-suggestive ID. She was part of a cooperation agreement. She had spoken with police officers. It's not unduly burdensome to ask the Commonwealth to have her undergo that, to make sure that she is identifying the correct person. And I think that's really what Creighton talks about here, as opposed to just like, oh, should the Commonwealth have done it? It's like, no, the Commonwealth has a duty with the suggestive nature of in-court identifications. There's no reason for them not to have done this out of court for Ms. Brown.
Do the cases say there must be a good reason for not having done a prior out-of-court ID, or that there must be a good reason for allowing the first-time in-court ID?
The latter, Your Honor. So
isn't the good reason that there is prior familiarity?
Well, with Ms. Brown, I would argue if she hasn't seen the defendant in 3 years and that she could or may possibly have been on heroin at that time, if a prosecutor is reviewing that file, it begs the question to me, why wouldn't you not have done a really simple civil ID procedure?
But I thought you said the good reason analysis looked not at whether there was good reason for not having done the prior out-of-court ID, but whether there was good reason for allowing the first-time in-court ID.
Correct. So then a first-time in-court ID is not allowed unless there is good reason.
Right.
I'm just saying, practically speaking, there really wasn't any, I can't really see any reason for the Commonwealth. I'm not talking about the legal definition of good reason in terms of these identification. I'm just saying practically, it doesn't really make much sense that they, given that 3 years had gone by, that they would not have allowed or not have undergone a non-suggestive out-of-court identification with Ms. Brown. And especially with the officers, as they are always in a police station, given their,
Does the Commonwealth have to show that it would have been impractical for it to arrange an out-of-court identification sometime close to trial, but not at trial?
No, I don't think any of the cases specifically state that. I know Creighton addresses it when it says there was no reason for the Commonwealth not to have given these two children an out-of-court non-suggestive ID of the defendant in the 26 months. So I mean, the Creighton court does address it. I don't necessarily find that it holds that, but it has been addressed. And then I would argue with, obviously, Brown's a much closer case, but with the two officers, you find that their ID is improper. I would say that with Cohen, there was no other evidence that my client was involved. She was pretty clear that she doesn't remember who sold her heroin that day. And then with Brown, she was really the only other evidence to my client's involvement, even if you find her ID okay. The two officers' IDs, I would argue, kind of act as corroboration. And given, that she was, involved in a cooperation agreement, I would say that the admission of those two officers' IDs could have very likely influenced the jury's decision to convict. Your Honors, have no other questions?
Seeing none, thank you.
No? Okay. Thank you, Your Honors.
Ms. Chesky.
Good morning, Your Honors, and may it please the Court. My name is Allison Chesky. I'm a second-year law student at the George Washington University Law School, appearing with the permission of the Court on behalf of the Commonwealth. And with me today at council table is ADA Emily Walsh. The trial judge properly admitted the three in-court identifications of the defendant in this case by three witnesses who were familiar with the defendant before the crime occurred, which is the standard for good reason to find familiarity with the defendant and make that in-court identification under Creighton. The first witness, Detective Capasso, was a police detective with the Somerville Police Department. He observed the defendant, as you mentioned, dozens of times prior to the offense during his patrols and surveillance of the area. Further, he was familiar with the defendant through his previous arrests with the Somerville Police Department.
He's the one who'd never personally interacted with him, though, right?
He never personally spoke to the defendant, no. But the second detective, Detective Cicerone, had personally spoke with the defendant at least one time prior, in addition to being familiar with the defendant from his patrols of the area and surveillance of the area. And then the third witness, Miss Eileen Brown, was a civilian witness. She knew the defendant through mutual friends for up to 5 years before the crime occurred, in addition to meeting with him multiple times a week for 3 to 4 months before the crime occurred. So all those witnesses do have familiarity with the defendant before the crime occurred, which is the standard for good reason for an in-court identification under Creighton.
So you're accepting that Ortiz applies, and that so you can't base it on the officers are the arresting officers. You're doing it. It's based on familiarity with the defendant, and they're actually doing an ID in court.
Yes, I do believe that we don't need to get to Ortiz because they are familiar with the defendant before the crime occurred. And so for that reason, exactly in Creighton, where in 2018 the court did find that an in-court identification was proper when a library employee identified the defendant based on him signing the initial W on a wait list to sign up for a library computer, and then later identified that defendant through the saving of illicit images to a library computer under that same initial W, this court found that that was a proper in-court identification. And then here, these witnesses have much more familiarity with the defendant when they've also observed him previous to the crime and saw the crime occur.
Does the record reflect why there wasn't a prior out-of-court identification?
For Ms. Brown, there was not a prior court identification, I believe because the police officers took a written statement from Ms. Brown in their vehicle at the time of when they stopped Ms. Brown after the purchase of narcotics.
I mean, they didn't do a lineup or show an array to any of them, right?
They did not, no.
But do we know why they didn't do that?
I don't believe that it's clear from the record, but I don't think that there was reason for it because when the police officers spoke to Ms. Brown, they seemingly understood that she was meeting with someone that she had met multiple times before and was familiar with the defendant, so there was not need for them to do an out-of-court identification procedure with Ms. Brown.
So in what case does an appellate court affirm for cause for not having an out-of-court ID? What's the weakest evidence? What case has the weakest evidence on which they affirm?
The weakest evidence in this case?
No, in another case. We're trying to figure out how, as Justice Meade asked defense counsel, what is how familiar is familiar? And so I guess, what's the case that's the least familiar that still passes muster?
Right. I believe that is Commonwealth v. Echevarria, where the officer saw an RMV photo from another witness of the defendant and then witnessed two controlled drug buys with that witness and the defendant in that case. And that officer still had sufficient familiarity with the defendant before the crime to find that he could identify the defendant in court. That was an unpublished case, but I believe that that's very similar to the circumstances here, where the police officers were familiar with the defendant before the crime occurred, watched two drug buys, and that was sufficient familiarity. Here, even if you were to find that one of the detectives' in-court identifications was improper, I do believe that that would not be prejudicial error because of the substantial evidence for both counts in this case. For Ms. Brown, I believe, as you mentioned in talking with opposing counsel, her identification stands up very strongly for the first count, but also there's evidence that she arranged to purchase narcotics, did purchase those narcotics from the defendant in this case, was stopped shortly after by police who found narcotics on her. And then with regards to the second count for Ms. Cohen, Detective Capasso and Detective Cicerone testified that they saw the same individual purchase or sell drugs to Ms. Brown and then also to Ms. Cohen. So even if you don't accept their in-court identifications as proper, they're still identifying that they saw the same individual, and then Ms. Brown's identification comes in that that individual was the defendant in this case. And further, with regards to both counts, once the police learned that the defendant had or got word that he may have fled to Logan Airport, he was found there with a one-way ticket, a substantial amount of cash, and 2 cell phones. If Your Honors have no further questions.
I have one question about the closing argument.
Yes.
The assistant DA said, I didn't ask, I believe she's referring to Ms. Cohen, I didn't ask Ms. Cohen to ID the defendant in this case in the courtroom because we already knew who it was because Detective Capasso saw who it was and saw him exchange the narcotics. So doesn't that imply that the ADA could have asked Ms. Cohen to identify the defendant?
I'm not sure that it does imply that, Your Honor, but even if it does, as I already mentioned, there was substantial evidence still with regards to Ms. Cohen. So even if that was error, it was not prejudicial in this case.
So you don't think that saying, I didn't ask her to identify the defendant because we already knew who it was, that doesn't imply that if I had asked her, she would have been able to identify the defendant?
I'm not sure that it does, Your Honor, but I can understand how you might read into that. So without conceding that, we just believe that even if the prosecutor's statement was an error, there was still substantial evidence in this case, and it would not be prejudicial error. But with that, I will rest on my brief.
Thank you. Thank you both. Nice job by both. Thank you, Assistant DA Walsh. Our next case is 22P947, Commonwealth versus ROSA. Mr. Demisi.
May it please the court, my name is Dereje Demisi, and I represent Mr. Helder Rosa. The issue presented in this case is the issue of ineffective assistance of counsel. Mr. Rosa argues the trial attorney was ineffective in not requesting a lesser included offense of assault and battery. At the close of the evidence, when the judge invited the defense lawyer to make such a request, defense lawyer declined to do so, despite the fact that he received advice from Mr. Rosa's immigration attorney of the serious consequences Mr. Rosa faced if he were to be convicted of aggravated assault and battery. And one of the suggestions, well, she made three suggestions, but all of them revolved around the need to avoid a conviction for aggravated assault and battery and to either resolve the case through a plea for simple assault and battery or obtain a sentence of less than 1 year.
So in terms of the options, the key thing is the SBI, the substantial bodily injury. So if he had been convicted of just assault and battery, would the immigration consequences depend on the sentence that he got, or would be home free?
It would still be. He would want to avoid a sentence of 1 year or longer. With simple assault and battery, the chance of getting a sentence of 1 year or less than 1 year is significantly high. With conviction for assault and battery with a aggravated injury, that would be unlikely. So the
conviction that he got, no way out. A lesser included conviction would be he'd need a sentence of less than a year.
Correct.
Okay.
So assault and battery less than 1 year would not trigger the aggravated felony provision of the Immigration and Nationality Act that pertains to deportation.
The judge said that none of those three options were on the table. The Commonwealth did not offer any of those.
The Commonwealth did not offer any of those. So once the decision was made to go to trial, the best strategy at that point available to Mr. Helder Rosa was to either get a not guilty on all charges or at least get a conviction for a lesser included offense of assault and battery and seek a sentence of less than 1 year.
When the judge threw out the idea of the lesser included, trial counsel said that he had spoken to the defendant and they don't want to do that.
And that's proven to be completely wrong.
Well, based on what, though?
Based on the email exchanges that we submitted
when did trial counsel have this conversation with the defendant?
Prior to trial, there were...
I'm sorry. Prior to trial, the judge did not offer or even discuss a lesser included. It occurred at trial.
Correct.
And he said he discussed it with the defendant, and he said he does not want to do that.
So the sequence is...
I'm sorry, that was a question.
Yes, I'm trying to answer that. The sequence is a little bit tricky because it's not clear whether he had conversation with the defendant when the judge raised the issue. What the lawyer said was he had prior discussion with the immigration attorney.
Right.
And based on the immigration attorney's advice, he was seeking he was electing not to seek a lesser included offense. However, we know what the immigration lawyer's advice was, which was why I said it was wrong for him to report based on the advice.
You said this is tricky, and I don't disagree, but what's also tricky for you is that you don't have an affidavit from trial counsel.
Correct. What I have is a series of email communication between trial counsel and the immigration attorney where he sought advice and was given specific instructions based on what she believed was in the best interest of Mr. Rosa.
But there's no indication, is there, that the immigration attorney ever said, don't go for a lesser included offense instruction? The immigration attorney's focus was, don't get sentenced to a year or more.
Or get a conviction for assault and battery less than 1 year, as I think.
Oh, sure, less than 1 year, but that's not something that that the immigration attorney can count on happening. If there's a conviction, the sentence is up to the judge.
Correct.
So when trial counsel says, in response to the judge's question about the lesser included offense instruction, the trial counsel says, based on discussions with the immigration attorney, we're not going to do that. Can't we interpret that as saying, based on, we think, or I think as a strategic matter, that the best way to avoid a sentence of 1 year or more is to refuse the lesser included offense instruction?
I don't think that would be a fair understanding of the position, because obviously a sentence of less than 1 year is more likely with an assault and battery conviction.
Yes, but so is a conviction. So is a conviction. Can't counsel be pursuing an all-or-nothing strategy, thinking if I accept a lesser included offense instruction, there's more chance of a conviction, and I can't control what sentence the judge gives then. Whereas if we refuse the lesser included offense instruction, the jury's got to decide between this more severe offense and a not guilty. And maybe we have a better chance of getting a not guilty if we only get instructions on the ABSBI.
Conceivably, however, based on what transpired between him and the immigration attorney and the defendant's understanding of what the lawyer was going to do, that would be inconsistent. I think the direction was clear that with aggravated assault and battery and a sentence of a year or more obviously would be likely, and the chance of being classified as aggravated felon was higher. And also, based on the record, I did not see any reference to the defense lawyer having a conversation at that point with the defendant, where he understood what the choices were. The defendant did file an affidavit saying if he had known, he would have elected to seek a lesser included offense, and he would have done everything to maximize his chances of not getting a year sentence.
Would you agree that not requesting something you're not entitled to is not ineffective assistance?
So I would say, based on this, based on the facts of the case, the defendant was entitled.
Let's start with the basic premise. If you're not entitled to a lesser included offense,
if he's not entitled,
and you don't request it, you'll agree that's not ineffective.
If he's not entitled to it,
okay.
Then
so to be entitled to the lesser included here, you're going to have to show that the SBI was in dispute, materially in dispute. And the trial judge, who is also the motion judge, who we owe great deference to, concludes that it wasn't disputed at all.
Correct. I think there are a number of hypotheses under which the jury could find Mr. Rosa not guilty of aggravated assault and battery, but guilty of assault and battery. And let me just offer one hypothesis that, in addition to what was mentioned in the brief, if the jury were to find the initial blow to the face excused by self-defense, because it was made in reaction to the complainant trying to punch or punching the defendant, and then found subsequently there were additional touchings as alleged by the complainant, they could find Mr. Rosa not guilty of aggravated assault and battery that caused the injury, even if you believe the injury happened. and even if the injury is not disputed.
But the Commonwealth has cited a case, and it escapes me at the moment, that says that a mere misbelief or disbelief in the Commonwealth's evidence isn't enough to put a material element in dispute for the purposes of a lesser included.
It's not a mere disbelief. There's an issue of self-defense here. So the issue
that would have been an outright acquittal if they found self-defense, right?
Self-defense as to the initial blow, but then they could have found additional acts of assault and battery. This was not charged as assault and battery with a punch. It was assault and battery in general. So they could have found that Mr. Rosa exceeded his self-defense privileges by continuing to punch or kick the complainant while he was covering his face. He did allege that after the initial blow, he covered his body, he was on the ground, and he was hit a few times. So they could believe some of it. They could disbelieve a portion of the complainant's allegations. In this case, they could have applied the law of self-defense as to the initial blow, find that that blow caused serious injury, but was excused by self-defense. But then the defendant continued to touch the person and find him guilty of assault and battery for those touchings. That's one hypothesis. The other one could be that based on the doctor's testimony that having gone through a surgery years ago, having a compromised pre-existing condition, while he was hunkering down or using a towel, he could have further injured his eye. Do
you have a case that says a mere supposition or hypothesis of how a jury could end up disagreeing with the Commonwealth's evidence is sufficient to put it in dispute?
Yes. I think I would point the court to Commonwealth versus Thayer, and it's at 132, I have the Northeastern version, 634 Northeastern 2nd, 576, 1994.
It doesn't require actual evidence, testimony, or argument. It could be merely an after-the-fact.
Well, what it says is, if any hypothesis of the evidence, the jury could have found the defendant
of the evidence,
guilty.
though.
Hypothesis of the evidence.
Yeah, but there's no evidence in your case that disputes the serious bodily injury.
So the evidence that disputes may not exist. The evidence that excuses the serious bodily injury exists. Self-defense is a complete defense to the initial blow to the face. It happened right after the complainant threw a punch. He admitted that. The defendant turned around and punched him.
He unsuccessfully threw a punch.
So if you believe the defendant's version, which the jury was free to believe, obviously that was part of the evidence, and they could completely credit that and discredit the complainant's testimony regarding that piece of the evidence. They could find that he threw a punch, connected, and the defendant retaliated or punched him in self-defense, but then he continued to touch him in some way, as alleged by the complainant, and committed assault and battery. So that would be the argument for that.
Just the question, I don't think you raised this, but the judge in sentencing said, "I'm not going to consider immigration consequences. I'm going to treat him just like everybody else." Is that an error? Is that an abuse of discretion? Or did it not matter because he was sentencing on SBI, so whatever he did wouldn't make any difference? That's maybe why you don't argue it.
So whether or not the judge should have considered the immigration consequences and given a lesser sentence, that's not something I argued.
A lower sentence, yes.
A lower sentence. But the judge did decide not to consider that in sentencing.
Could he have taken the immigration consequences into account in sentencing?
Judges do consider that. I'm not sure if they're required to. A lot of judges do consider immigration consequences.
Fair enough. Thank you.
If there are no more questions, thank you.
None.
My
Thank
time
you.
is almost up.
Ms. Sakanofi.
Good morning. May it please the court. Kyle Sikanolfi for the Commonwealth. I'm joined here today by the trial prosecutor, ADA Caitlin Grasso. Today, the Commonwealth asks this court to affirm the defendant's conviction for assault and battery causing serious bodily injury and affirm the denial of the defendant's motion for new trial. Excuse me. In this case, trial counsel's decision with his client not to request the lesser included offense instruction did not constitute ineffective assistance of counsel. In the evidence at this trial, the defendant was not entitled to that instruction, and we know from the motion judge, who was the trial judge, that had it been requested, the judge would not have given it. For these reasons, the actions of the defense attorney in counsel with his client and contemplating the advice they had received, this attorney chose a tactic that was readily available from the Commonwealth's own theory of the evidence, a self-defense theory. And he chose that tactic, adding a burden to the Commonwealth to disprove the theory of self-defense. And he chose that tactic seeking the all-out acquittal of his client, which again, there was a basis in evidence from the Commonwealth's own version of the case for him to do that. There was not a basis in the evidence for him to request instruction on the lesser included offense of assault and battery, where there was not sufficient dispute of that element, serious bodily injury, which distinguished it from the lesser included assault and battery. There wasn't sufficient dispute of that at trial, and really there was none. The uncontroverted evidence was that the punch from the defendant caused that devastating injury.
What if the first punch was in self-defense?
Well, I don't think that the challenge here is whether this self-defense theory was such that the jury necessarily needed to acquit the defendant. The question is whether there was any dispute that the punch caused that significant injury. And here, that was the only conduct on which the Commonwealth proceeded to trial. Any subsequent touching that the victim spoke to was given in context to his version of the events, and it was contested by the defendant, and it wasn't the subject of the indictment that went to trial. So I don't think that the theory first raised by defense today, that the jury could have picked and choose whether any portion of the defendant's conduct was justified by self-defense, I don't think that's borne out in the charge they were asked to evaluate at trial or the evidence at trial. In terms of...
Was the theory advanced in the motion for new trial?
That the jury...
They could have found the first blow, the one to the eye, that they could have found, excused by self-defense, but then a subsequent blow not excused.
No, I don't believe that was raised in the motion for new trial. And there was also the hypothesis raised that was addressed in the motion for new trial, which is whether the jury could have attributed the significant injury to the victim's touching of his face or use of a towel after the attack unfolded. And that's simply not, I don't believe that to be an accurate characterization of the trial evidence, where it was undisputed that it was the first contact, that punch, that caused his eye to, quote, explode, and that he sought the towel really to clean up the fluid that was coming from his eye. Where that's not disputed, the defendant would not have been entitled to the instruction for the lesser included. And counsel's performance, therefore, in not requesting it, didn't fall measurably below that which you'd expect from an ordinary fallible lawyer. Likewise, even if, as the defense has posited today, another attorney may have made that request, the counsel's choice not to didn't deprive the defendant of any substantial grounds of defense. We know from the trial judge that he would not have given the instruction having assessed the evidence at the trial. So the defendant can't meet his burden on that second prong.
Why did he, if he wouldn't have given it, why did he ask if they wanted him to give it?
I think it was a fair opportunity to asking of both parties whether there were any special or instructions beyond the standard model instruction that the judge intended to give. I think it was, if it's to be characterized as an invitation, I think it was an invitation to air whatever the party's position may be with respect to instructions generally. I don't think that changes the judge's assessment that he states in his denial of the motion for new trial that he wouldn't have given it, because the trial transcript also reflects that the judge, with the party's concurrence really, the judge stated, you know, there's really no version of this that isn't serious bodily injury. And he says that at that same time where they're talking about whether there'd be any other instructions beyond the model. And defense counsel joins in on that and agrees that this is the nature of the evidence.
You said that there's no prejudice on two grounds. First, that the judge wouldn't have given the instruction if requested, and second, that even if the instruction were given, no rational jury could have convicted of the lesser included. But if that's true, why would the ADA argue so vigorously against the lesser included instruction? If no rational jury could convict on it, then what's the big deal?
I think that was advocacy for a verdict based on the evidence at trial in conformance with the law, rather than an opportunity for the jury to provide a verdict that wouldn't be based on the evidence. And I think that that's...
So juries sometimes do that?
I think juries do things that we don't always appreciate the understanding of. And I believe that this was advocacy that they be instructed in accordance to the law that was relevant for the evidence they received at the trial, and that they ultimately, when the verdict is returned, it's one based on the evidence at trial. If there's no further inquiry from the panel, the Commonwealth would rest on its brief.
Amen. Thank you. Thank you both.
Thank you.
The next case is 22P 10090, Commonwealth versus Diggs. Ms. Roosevelt.
Good morning. May it please the court, my name is Anne Rusev and I represent Damian Diggs. This case is the appeal from a denial of a motion to suppress, and we're here pursuant to a conditional plea. There's two issues in this case, one involving the frisk, one involving inevitable discovery. I'd like to start with the frisk, if I could. There's no question that Mr. Diggs was seized when he was ordered to the ground, handcuffed, and then frisked. The frisk is only permissible if the police have a reasonable suspicion that, one, he's committing or about to commit a crime, and two, that he's armed and dangerous.
Can I stop you right there?
Yes.
Is reasonable suspicion that he has or is about to commit a crime the only conceivable basis for a constitutionally justified, I guess we'd call it a brief seizure? I mean, the police are there executing a lawfully issued search warrant. They can't have people inside the house running around and potentially interfering with the search. So isn't it permissible to confine your client to a particular room while they're engaged in the search?
Perhaps. And so perhaps under that type of argument, the initial order to get on the ground might be permissible to give the officers an opportunity to secure the scene. Where the problem arises is at the moment of the frisk, because it's very clear that you need reasonable suspicion, both that he's armed and dangerous and that he's about to commit a crime or...
Well, that second part is what I'm not sure about. Why can't the police say, you got to stay where you are, and then if he does, obviously if he's not, no reasonable suspicion that he's armed and dangerous, then no basis for a pat frisk. But if he's secured in a room and yet they have reasonable suspicion to think that he's armed and dangerous, why can't they frisk him? Why do they need... I mean, he's confined, he's temporarily seized. It's not based on reasonable suspicion that he just committed a crime or is about to, but still they've lawfully seized him temporarily.
I see. Well, I think, so if you look at Narcisse, they talk about sort of the melding of these elements. So under the analysis of armed and dangerous, if somebody appears to have a weapon and appears inclined to use it, that demonstrates that they're armed and dangerous. That also gives you reasonable suspicion that they're about to commit a crime, some type of assault.
Okay. So we could just focus on armed and dangerous.
I think that we can, yes, in this circumstance. And the Commonwealth failed to demonstrate reasonable suspicion that Mr. Diggs was armed and dangerous. I think the critical fact here is that the officer knew prior to the frisk that the item in Mr. Diggs' hands was not a weapon. The Commonwealth argues on appeal repeatedly that this item was unidentified or unknown, and that is simply not true. The officer is very clear over and over and over again that he identified the item as clippers prior to the frisk. The testimony is so clear, in fact, that the prosecutor below acknowledged this fact repeatedly at each of the 3 hearings in connection with the motion to suppress and in a written memorandum. It's clear from the testimony that the officer knew he had interrupted an at-home haircut. He knew the small item in Mr. Diggs' hands was clippers. He had an opportunity to scan the bathroom to see the case for the clippers there. He knew Mr. Diggs and the second gentleman complied immediately with the order to get on the ground, and he knew that there had been no threatening or furtive gestures. So at that pivotal moment right before the frisk, while these 2 men are handcuffed face down on the ground, completely compliant, completely subdued, neither one of them was armed and dangerous, and yet they were both frisked. Where the motion judge erred is he never assessed armed and dangerous. He looked at, is there a reasonable safety concern, which is not the analysis. Narcisse and Torres Pagan make very clear that a safety concern, no matter how genuine, no matter how reasonable, is simply not enough for a frisk.
So what's so unreasonable about thinking that a haircut involves scissors as well as a clipper? So if he's got the clippers, there could be scissors.
Right, so I
think
think
he could have them in his pocket.
That's the only sort of justification that's left, right? Is he's not armed and dangerous by virtue of the clippers, but by virtue of the participating in a haircut itself. I think dangerous in this context, it's important to remember, means likely to use a weapon or inclined to use a weapon.
Okay, so just to be clear where we are,
yes.
Did you just acknowledge that there could be reasonable suspicion that he's armed?
No, I don't acknowledge that because he's...
scissored?
I'm sorry?
Not that he's armed, but that he's scissored? That he's scissored?
That he's scissored.
Yeah.
He's in possession of scissors?
Yeah.
No, I don't believe so, because remember, at this moment, he's face down on the ground. He's dropped the item in his hand, so we know that his hands are empty. His hands are handcuffed behind him. So there's nothing that's in his hand. He's not able to reach for anything because he's incapacitated on the floor. So there's no evidence to suggest that there was another item present. The officer had a moment to scan the bathroom.
Help me out with the record. Does the motion judge in reconsideration say exactly this, that he thinks that there was reason to believe he could have another item on him?
Yes, that is...
Okay, so that doesn't also mean that he's able to access it, right?
Well, again, the judge doesn't do the armed and dangerous analysis. He finds it's reasonable to suspect that there's another item there because of the haircut, and that gives a reasonable safety concern.
Right, and the safety concern is because he's armed.
Well, that's different, though. You need both armed and dangerous. Our position is there's no evidence that there's another item there. This is an at-home haircut in a bathroom. We know there's electric clippers. You see the case for the clippers. The officer scans the bathroom, doesn't see anything else. And this is not a full-service barbershop where you might expect, yes, a razor, scissors, all kinds of implements.
I mean... The hair clippers are there. He's giving him a haircut. Is it unreasonable to think that there are scissors present?
I think it
might be reasonable to guess that they're not present too, but
our position
could there be a reasonable suspicion that something else or scissors are present?
I don't think so, because I think it's very, very common for men to receive haircuts with just electric clippers, and that's all, especially when you're not in a barbershop.
Some men just get haircuts with scissors.
Certainly, some men do, and if...
Some men don't want clippers anywhere near what hair they have left.
Well, this gentleman, the second gentleman here, clearly did not mind a haircut with a buzzer, because that's what was happening, and we don't have any other evidence that there's other items here. And so I'm not conceding that it is reasonable that there's other items here, but even if it is, that doesn't get you to dangerous, because there's no evidence that Mr. Diggs specifically would be likely to lash out with a weapon. Because what do we know about him? We know that he complied immediately and he dropped to the ground. We know that he dropped the item. We know that he was handcuffed without incident, that he put up no kind of fuss at all. We know that the officers didn't recognize him prior to the frisk.
Can we take the handcuffing into account as decreasing his dangerousness? Because eventually, assume that he's not pat frisked, assume that the search is completed. Eventually, if he's not arrested, then the handcuffs are going to be taken off. So if he's armed while the handcuffs are on, and the only thing that's preventing him from being dangerous at that instant is that the handcuffs are on, once they're taken off, isn't there still a risk to the officers?
Maybe in a theoretical case where you have some type of threatening gesture, a furtive gesture, something that suggests that this person could be violent towards officers.
I'm not suggesting that it creates dangerousness, but it doesn't remove dangerousness that might otherwise exist. The mere fact that you're temporarily handcuffed, it's kind of like when you take someone out of the car and you pat frisk them, there's nothing, but if they're let go, they're going to get back in the car. So I think the law is that an officer has the ability to, the right to look around the immediate area where the person will get back in the car.
Yes, that's true. But prior to that, you still have to have a reasonable suspicion. We don't have a reasonable suspicion of dangerousness here because he's compliant, because he's cooperative, because
all
we don't have all that.
All I'm trying to get clear at this point is that we don't count the fact that he's temporarily handcuffed in deciding whether there's dangerousness.
Yeah, I would say it's a factor. It's not dispositive, though. His behavior and the fact that they have no prior knowledge of him being dangerous or aggressive, I think that is what really carries the day, because there's nothing. And again, Mr. Diggs was not known to these officers. He was not implicated in their investigation in any way. He was not on their radar. They encounter him when they first come in, and he's completely cooperative. So all of their knowledge of him is just this cooperative gentleman who complies and who happens to be giving a haircut. That's the universe of knowledge, and that is not enough to show that he's dangerous.
So on the inevitable discovery,
yes.
They've got a warrant to search for drugs and evidence of drug distribution, and they certainly would have found the satchel, and with evidence of drug dealing in it, and the defendant's ID. Wouldn't that have given them probable cause to arrest him?
No, because there's no substance found there. So what crime is there probable cause of? Certainly not distribution or possession with intent, because you don't have.
Well, he has all of the cut baggies and whatnot are all consistent with distribution, and your sister says with some force that he could be charged with conspiracy to violate the drug laws.
And the problem with putting aside the threshold issue about whether the Commonwealth's argument rises to the level of appellate argument because it's contained in a one-sentence assertion that's devoid of legal citation, putting that aside, it still fails on the merits because you need proof of an affirmative proof of a prior agreement for conspiracy, and there's nothing like that here. There's no connection between my client and the drug investigation.
What you're talking about are nifty things that come up at trial instead of probable cause. He's there at a house that's been suspected enough to generate a search warrant for drug distribution, and he's in possession. Unquestionably, his satchel, not only does it have his identification, his mom says it's his, and there's indicia of drug distribution items within the
Yes, and if I could this is a small point, but the mother doesn't testify that's his satchel. She testifies he sleeps in that area. The judge finds that she made that statement. She didn't make the statement. I don't think it matters too much because there's other evidence that it's associated with him, right? But our position is there's no probable cause because there's no proof of a controlled substance so that you could charge distribution. There's no proof of an affirmative agreement, so you can't charge conspiracy. But even still, there's two other points of failure.
You're too far into the weeds. What we're talking about at that moment, is there probable cause to arrest him for something? Because we know when he does get arrested, he's going to be charged as part of the distribution
I mean, it could be as a joint venture, not as a co-conspirator.
Right.
But joint venture for what?
Distribution of drugs.
Distribution, yeah.
Distribution of what drug? You need to identify the substance. Distribution of Class A, Class B, we don't know because
There
there's
was
no drugs
no
found.
drugs found in the search? No drugs found in the apartment?
There's no drugs found in the apartment.
There's drugs found on him, though.
Right, but you only get there if you have a lawful basis to search him.
But you're saying they needed probable cause to believe he had drugs on him to arrest him for drugs, as opposed to, based on what the police did know at that moment in time, did they have probable cause to arrest him as part of a conspiracy?
Right, and without proof of an agreement, they don't have, or evidence, any evidence of an agreement, they don't have probable cause for conspiracy. But even if you assume for the sake of argument, they have probable cause, they're going to make this arrest, or they believe they have probable cause, there's no testimony that they certainly would have arrested him. Detective Cummings is asked directly, have you ever made an arrest when somebody is on premise but does not have drugs on them? And he says, well, it's up to a supervisor. So it's a discretionary decision. And under Barrows and under Campbell, the fact that the officers could have made an arrest does not determine that they would have made an arrest in the absence of the illegally seized items.
So if we were to agree with you that the pat frisk was bad, would we need to remand on inevitable discovery? Because there's no finding of fact about either whether he would have been charged or whether he would have been arrested.
Right. You don't have to, for two reasons. One, because the record is fully, and I do mean fully, developed. We have evidence that was brought in, we have testimony, we have documents, we have arguments over 2 hearings, 4 written submissions.
You just told us there was no finding made on whether or not he would have been arrested.
There's no evidence that he would have been arrested.
Well, the officer testified that on some circumstances, yes, and he was going to have to speak to his supervisor.
Right.
So they're going to need to, someone's going to have to make a finding of fact along that line, perhaps in your favor.
No, I don't believe so, because you can assume the truth of all of the testimony that was presented. The Commonwealth and the defendant went in prepared to litigate this issue. They fully litigated it.
Not fact
finders.
The judge didn't. You're talking about finding facts.
Well,
the judge doesn't have to believe everything that was said to him.
He certainly doesn't, but even if you accept everything is true here, it's insufficient. And I think you can look at the Daniel case where the SJC looked at an argument where it wasn't made below. The Commonwealth argued that there was probable cause to believe that this person was driving under the influence. It was made for the first time on appeal, so there was no opportunity for the judge to make factual findings. And at the SJC still went ahead and looked at that issue, and they said, even if we accept all of the testimony, including testimony that was not specifically credited by the judge, we still find that it's insufficient here. So you can accept the testimony.
That's cited in your brief, the Daniel case?
No, it's not. No? But it's a 2013 case from the SJC.
Okay. You say that we have all the evidence we need to decide this, but the Commonwealth didn't put on evidence about what the policy might have been at the Brockton Police Department about when you charge someone after a search and when you arrest someone after a search.
Well, they certainly tried to, but I don't think they got the evidence
well,
they were expecting.
They only called 2 witnesses, and the senior of the 2 witnesses said there were other people on the scene who would have made that decision, but those people weren't called. Is there any reason that the Commonwealth shouldn't have the opportunity to present any such evidence that it has if we were to rule in your favor on the pat frisk?
Yes, because they had a full and fair opportunity to litigate it. The issue of inevitable discovery
So the motion
came into play.
did the motion to suppress itself raise the issue of there was no inevitable discovery here, or just said the pat frisk was bad?
So initially, the motion said, all persons present, that clause is invalid.
Right.
Then the Commonwealth said, well, but we have a separate basis for the pat frisk, and there's inevitable discovery. So that motion is filed prior to the hearing. The defendant files another supplemental motion saying the pat frisk is bad and there's no inevitable discovery. So you have litigation pre-hearing about inevitable discovery. You have the Commonwealth coming in, submitting the document, the booking policy about searches. You have the Commonwealth putting in evidence through the detective about when people are arrested. So the Commonwealth came in fully prepared to argue this exception to the exclusionary rule. The fact that they didn't succeed in that opportunity doesn't mean that they get a second chance. That was their one opportunity. The fact that the judge didn't reach that issue because he agreed with them on another ground doesn't mean they get a redo for this issue that they've already fully litigated.
Okay. Thank you.
Thank you.
Ms. Marble.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. Your Honors, this is a close call. I concede that, but this is not a situation where an officer goes in and has even 15 minutes to stop, ponder, think about, look at, rethink, what if, what if, what if, what if. The testimony was very clear, and I tried to relay that in the Commonwealth's brief, that this was an unfolding very quickly situation. And granted, Stampley, which was cited in the defendant's brief on page 20, talked about response to an unfolding encounter and about there not being a hasty reaction and that being the hallmark of reasonableness. But the SJC also said, in looking at safety concerns, you're looking at the entire circumstances of the encounter, and that does not require split-second precision suggested in that analysis. Again, that had to do with an exit order, but I think in looking at officer safety, we have to really think about what was happening here in the moment.
So what was the basis for any reasonable suspicion that the defendant was dangerous?
I think if you look at the testimony, particularly around page 33 of the transcript, where the detective talks about this was quickly unfolding. I went in, I didn't know what it was. We're 5 to 7 feet away. I'm ordering him to the ground. I have my hand on his back. I'm taking a quick look. There's a second male.
Things were happening quickly. We can grant that. What is the basis for reasonable suspicion that the defendant was dangerous?
I think once he realizes that, okay, that's not a weapon, a gun, it's clippers. He also doesn't know. He says, I looked in the bathroom, there was a black small satchel, presumably, or a case, presumably where the clippers would belong, but he doesn't know what other items are there. He doesn't know what other items he has on him, and he does that quick pat frisk of both of the males. Again, you have 2 males, okay. 1 officer.
So, seeing that a haircut was in progress, there might be reasonable suspicion that there are other hair cutting tools around. So correct. There might be a reasonable suspicion that the defendant is armed.
The officer doesn't know, and that's the reason.
Right.
Correct.
Let's assume there was reasonable suspicion that the defendant was armed. What's the reasonable suspicion basis that he's dangerous?
So we're having to articulate that you're armed and dangerous as opposed to armed and not dangerous? I think the officer...
Doesn't the Knowles case say armed and dangerous with and emphasized?
Correct. I would think that the officer, in seeing that there have some sort of weapon, it is going to be a dangerous situation.
So if you have a weapon, then per se you're dangerous? You're saying that you don't have to make separate determinations, or there doesn't have to be some basis for thinking that a suspect is dangerous other than the fact that he's armed or maybe
I think you have to look at the totality of the circumstances. Again, you're in close quarters, 2 males, 1 officer, quickly unfolding. If he thinks he has scissors, a pen can be a dangerous weapon. I mean, anything that he thinks can inflict some sort of injury to him.
So let's say that there was no haircut in progress, but as a regular part of the search warrant, orders him onto the ground, maybe handcuffs him, then he sees a pen in his pocket. That could be used as a weapon. Can the officer say, well, if he's got 1 pen in his pocket, he could have another pen in another pocket, and those are weapons, he could be dangerous, I'm going to pat frisk him. Is that permissible? I mean, don't you have to, the pen may be a weapon, he may be armed, but what's the basis for any reasonable suspicion that he's dangerous?
Again, I think it's the totality of the circumstances. Just because it's a pen doesn't mean that he is.
Well, you can say the totality of the circumstances, but the SJC did go out of its way in the Knowles case to emphasize armed and dangerous. Just being armed is not enough. And I suppose just being dangerous isn't enough. If the defendant had said, I'm going to punch your lights out, he may very well be dangerous with his fists, but that doesn't make him armed, does it?
No, not necessarily.
Okay, so you have to have a basis for reasonable suspicion of him being both armed and dangerous. It seems like that's what the cases say.
That is what the cases say. They do put the two together. But again, there are so many variables that one could throw out. I mean, the detective also testified, I didn't even realize I had dealt with him in the past on a firearms case. You know, what if he had realized that as soon as he went in? Like, I've dealt with him. I've known he has guns.
But he didn't.
Again, there are so many what ifs. We have to look at what the testimony was that the motion judge had before him that he could weigh. He witnessed a very lengthy cross-examination of the detective.
Did the motion judge say what it was that provided the reasonable suspicion for the defendant being dangerous?
He had two written decisions. And my recollection is that it was the articulately, I apologize, Your Honors, it is in the...
I couldn't find it in either of them, but...
Again, he goes back to, as was discussed previously, the potential for other tools and the coming out of the room.
Could be armed.
The short distance between the two, correct.
Could be armed.
That is what he relied on.
Yeah.
Correct.
Okay. But he didn't really separately analyze dangerous.
He did not.
Okay.
In either of the decisions.
If we ruled that the Pat frisk was bad, then do we need to remand on the inevitable discovery issue, or can we decide it?
I would say yes. I would say that that wasn't fully developed. There was no findings of fact made by the judge in either way.
Well, should we remand for findings of fact but no further evidence?
Well, I don't...
Let's put it differently. Did the Commonwealth have a fair opportunity to present evidence of inevitable discovery?
I don't think it did at the initial hearing, of bringing in of those initial witnesses. I think that was something that developed when there was a motion to reconsider, a renewed motion to reconsider, and it sort of developed as it went on from there. But my recollection of the initial motion to suppress was about the frisk and the reasonableness of that. I think the inevitable discovery, if I recall correctly, came about by the prosecutor making an argument. And again, could she have brought in additional witnesses in sort of a preemptive strike, if you will? I suppose she could have. That doesn't necessarily mean that it was developed. I mean, the judge certainly didn't make any findings either way, so we don't know if in fact there was enough to come to any sort of conclusion on that factor. If there are no further questions, I thank you for your time and would rest on the Commonwealth's brief.
Thank you both. Well done by both. Thank you.
Thank you.
Our last case is 23P 357, Mary Alberti versus Jonathan Alberti.
Good morning, Your Honors. May it please the Court, Your Honors, my name is Mark Cerrone. I represent the plaintiff, appellant Mary Alberti, personal representative of the estate of her late husband, Joshua Alberti. Your Honors, the main issue before the Court today is that the motion judge erred when she relied on the dictionary definition of the word respective when interpreting the trust, rather than ascertaining the intention of the donors from the whole trust instrument. Relying solely on that word, she committed reversible error by denying our motion for summary judgment and then taking it a step further by granting summary judgment for the defendant, who did not even move for summary judgment, and who is not here today.
Where is he? They almost defaulted, and then they had to remove the default?
Right, and this has been going on for a long time, Your Honor, because he defaulted, then he moved to have that emergency motion to have that vacated, which was allowed. You know, then we went through COVID, and then it's been a long process.
Mediation.
Mediation. We had to compel him to respond.
Did the mediation actually occur? It was a little unclear from the record.
So that was the most frustrating thing, Your Honor, about this, because
just answer the question.
Yes.
At least at
yes,
first.
It did.
It did occur.
Mediation occurred. However, it occurred after the motion judge issued her order. So when we were in court that day, August 1st, 2019, she basically begged us, go to mediation. This is a close-knit Italian family. You guys figured this out. Begged us to go to mediation. We immediately, the next day, scheduled mediation with Judge Delvecchio, and before we could get there, August 9th of 2019, 9 days after our hearing, she submitted her order denying our motion for summary judgment and granting it to the defendant, who didn't even move for it.
But do you have any insight into why the defendant, that is relevant to the issues on appeal, about why the defendant is no longer pursuing this, or is not here to defend?
I don't, the answer is no. I do not know. I don't know if it's a tactical move by him. I don't know if he's not paying his client. I have no insight on that, Your Honor.
Let's go back to 4.4. That's where you.
What's that?
Before we derailed you, let's go back to 4.4.
4.4?
Of the irrevocable family trust, right?
Yep.
Or the family irrevocable trust.
Sure.
So your theory is that under this thing, it had to be both donors or none?
The power of appointment needed to be executed by both donors.
So there's, what I mean, yeah, so you make, you know, at the time that these documents were all executed,
yep,
everybody's alive, right? You've got, you know, the donors, both donors are alive, right, both sons are alive.
Right.
And you don't know what's going to happen in the future.
Right.
So, I mean, isn't there a likely scenario that one of the spouses, the donors, predeceases the other?
Sure.
And at that point, and excuse me, we don't know how the second one could live for 10 years, 20 years. They don't have the power, if, say, they get mad at their other son, to cut them out of the will? He's stuck in the trust? They have no power to change their mind?
That's correct, Your Honor, because if you look at the totality of the documents, they went to deep measures to make sure their sons were going to get equally everything. It was evident throughout all the estate planning tools that they did, which I can get into.
The sons, what about the heirs?
Well, that's a big part of it, was that they love their grandchildren. And by doing what Jonathan, the defendant, did, it cut out the ability for 3 of their grandchildren to get anything, because it was going to go to the son Joshua. He passed away, so it goes to his estate. He had 3 children, and it was totally cut out.
But he was actually cut out by his mother.
Well, I mean, but as we stated in our brief, the motion judge agreed with us on this. The realty trust, amendment to the realty trust was invalid. He tried to cut him out by changing the beneficiary of the realty trust and giving it directly to him individually, where when the estate plan was drawn, it was going to the irrevocable trust. So that's the first thing he did to try to cut his brother out. Motion judge agreed that was invalid because Jean, the mother, signed that as individually and as trustee. She wasn't a trustee of that trust. She was the donor, and that was it.
Did you say the motion judge agreed that the amendment to the realty trust was invalid?
Yes, to the realty trust. Yes.
Where is that?
I believe it's part of her order, but she moved into because the realty trust, the beneficiary of the realty trust was an irrevocable trust. Everything hinged on her was saying that the irrevocable trust was amended by Jonathan, the last living brother. And the crux of the matter, Your Honor, is that was also invalid because the power of appointment that was exercised to amend the irrevocable trust needed to be signed by both donors. And Joseph was no longer alive, so when Joseph, the father, died, the power of appointment was extinguished. For that very reason.
So, but the second part of that, it says during their respective lifetimes. I mean, that does seem to talk about two different lifetimes.
Well, I think at the very least, Your Honor, maybe it is unclear, but the word respective is immediately followed by lifetimes in the plural, meaning both. We read it to be both lifetimes. And the reason, Your Honor, it's easy to distinguish that because if the only time everything's hinged on this word respective. The entire rest of the trust talks about the donors in the plural, talks about always the two of them. Then there's no language in there that says any one of them, anyone can act, the survivor can act individually. That language is just not present throughout the document. And Your Honor, it wasn't a Scribner's error as far as we're concerned or anything like that, because if you look at other language in the irrevocable trust when it relates to the trustees, not the donors, when it relates to the trustees who were the two brothers, they used that singular language, that any trustee could act, that one trustee could act. But when it came to what powers the donors had, it was always, without doubt, in the plural throughout all the documents. And the case law is pretty clear on this. Hillman versus Hillman says, you cannot take one word out of context. You cannot take one word in isolation.
But it's also disfavored to take one word and read it out of the document. You're basically saying we should ignore the word respective.
No, Your Honor.
There's that we should not give it effect in light of similar provisions elsewhere in the trust.
Correct, and the fact the word lifetimes follows the word respective. We read it as both their lifetimes needed to be that power to be exercised, to both their lifetimes had to be present. Obviously, a lifetime could be extinguished, but the power of appointment can't be extinguished.
Can I go back for 1 second and ask you to identify where the judge said the amendment to the Realty Trust was invalid? I'm looking at Record Appendix 55, which is the next to last page of her order, and she says all of the existing beneficiaries of the Realty Trust signed the amendment. That Jean signed the amendment, both individually and apparently incorrectly as trustee of the Realty Trust, does not void or make the amendment to the Realty Trust invalid. So I'm not seeing where she concluded
it may have been in the actual courtroom that day, because she moved. May have been in the courtroom that day where she mentioned that, but she agreed.
She said in the courtroom
she agreed that the Realty Trust that was invalid because the trustees needed to sign the amendment to the Realty Trust, and Jean wasn't a trustee. It wasn't accurate.
Right, but where in the transcript does she say that the Realty Trust is invalid? Is there a mismatch between her written order and what she says in court?
I'll have to go back to look at her transcript, Your Honor, but that's the way we remembered it when we did our brief. That's correct.
Well, let's assume that the Realty Trust amendment is invalid, so that the Family Irrevocable Trust remains the sole beneficiary of the Realty Trust. Yeah. If the Jean's exercise of the power of appointment was proper, and I understand you argue that it wasn't, but if it was proper, then essentially it resolves the case and the house goes to Jonathan. Is that accurate?
If the power of appointment, if she was able to exercise the power of appointment by herself?
Yes.
Yeah, yes. I mean, that's...
Okay. So it kind of doesn't matter whether the Realty Trust amendment was valid or not? I mean, if the exercise of the power of appointment was invalid, then do we need to decide whether the amendment to the Realty Trust was valid?
No, because the beneficiary of the Realty Trust was the irrevocable trust. So if the irrevocable trust, if the power of appointment was invalid,
all right,
the irrevocable trust is still valid.
Right, unless the amendment to the Realty Trust validly changed the beneficiary of the Realty Trust from being the Family Irrevocable Trust to Jonathan individually.
Yeah, I mean, yes, Your Honor, but I don't see how you can say that when she signed that as a trustee and she wasn't a trustee.
Well, but what if her signature wasn't necessary at all? The fact that it's on there, she was not a beneficiary or a trustee of the Realty Trust. That's not disputed, but why does her signature being on there invalidate a document that might otherwise?
She was the donor, and she But I guess she was signing something in a capacity that she never held that title.
Right.
So, I mean, that's, you know.
It might be unnecessary, but does it invalidate the document if the document was otherwise valid? If Jonathan had the authority to sign in the capacities that he did?
We believe it's not, no. I mean, it's not, did he have the ability to sign it but he was changing the benefit. Also, Your Honor.
All the beneficiaries of the realty trust had to sign in order to make an amendment.
Right. Yeah, correct. And she wasn't a beneficiary.
Right.
Yeah.
But if he was the only beneficiary, then isn't his signature adequate?
No,
and is it invalidated by?
But he wasn't the only beneficiary. The beneficiary was the irrevocable trust. I mean, we're going in circles.
He was trustee of the irrevocable trust.
Correct. And they're both the beneficiaries of the irrevocable trust. And that needed to be, anyone to sign the amendment had to be signed by the beneficiaries of the realty trust.
Right. And the beneficiary was the irrevocable trust
Correct.
at that point.
Correct.
So doesn't he, since he was the only remaining trustee of the family irrevocable trust?
He wasn't.
His brother had died.
Yep.
Was a successor trustee appointed for the irrevocable trust?
His brother died, but the beneficiaries had to sign the amendment to the realty trust. Okay? So the brother had died, correct, but if the schedule of beneficiaries for the irrevocable trust states that it is Jonathan and Joshua, so it would be his estate. So sorry, go ahead. I'm sorry.
In their capacity as trustees of the family irrevocable trust, not individually.
No, but they're the beneficiaries of the irrevocable trust. They're the ones who have to sign any schedule of beneficiaries, any amendment to the realty trust. That had to be signed by the beneficiaries, which was the irrevocable trust.
The irrevocable trust was the beneficiary of the realty trust?
Correct.
All right. And at the time the amendment to the realty trust was signed, was Joshua still alive?
No.
Okay. So the only trustee of the irrevocable trust at that point was Jonathan?
Correct.
All right. So who acts on behalf of the family irrevocable trust other than the trustee?
The trustee has to act for the benefit of the beneficiaries.
Okay, but he can sign. Now, whether he breached his fiduciary duty as the sole trustee of the irrevocable trust might be a separate question. But
yeah, it clearly did.
If he signed as trustee of the irrevocable trust, then that trust is the beneficiary of the realty trust. So why wouldn't that be sufficient to amend the realty trust?
Well, again, because the realty trust needs to be amended by the beneficiaries. And the beneficiaries were still, I understand Joshua's gone, but his estate is still there. So Mary, if what you're suggesting is Mary, as personal representative, our client, the plaintiff, she should have been the one who would have to sign that as well. To make that amendment effective, she would have to sign it as well. Because that is still there. But, I mean, Your Honor, the plural, if it's throughout the document, she's using in the plural. And the motion judge said that's that had no merit to it. I mean, that's just not the case law. Of course it has merit. So that was very disappointing to hear that, Your Honor. I mean, and we were deprived, well, we're asking the court to grant.
I wanted to ask you about that. You said you were deprived of in your brief, you said you were deprived of the opportunity to present some extrinsic evidence. Right. Couldn't you have put that in your motion for summary judgment?
Well, we were just at the time arguing the document itself, the validity of those amendments that were filed. That was the motion.
If it's wasn't part of your argument that you have to look, that it's ambiguous on its face, you have to look at other things?
Well, we would, if it went on to remand, that's exactly what we would do.
No. Why didn't you do that in the summary judgment argument? When you moved for summary judgment?
Because it was a different trust. We were talking about the right. Document itself, that trust, the validity of that one trust.
Right. So you didn't think at that time that the family living trust was relevant?
Right, because we thought that the trust itself was something that wasn't necessary just by the four corners of that document.
So the living trust is not part of the record, right?
The living trust
is not part of the record below, right?
Record
It's
below,
not,
no.
it's not part of the summary
No,
judgment.
no.
But I just want to ask you about this because there's three trusts that were all on the same day.
Right.
There's the family irrevocable trust, there's the realty trust, and then there's this living trust.
Right.
What's in the living trust?
It's the repository to their wills, which states, again, everything goes to the two of them individually equally. The evidence
it covers the same property that's in the other two?
No. This is just another.
What property does it cover?
Well, I guess the residuary of their wills. It's the repository of their wills. So,
and that's not all. And there's something besides what's in the. There's three things. There's whatever's in the irrevocable trust.
Yeah.
Which is now. It's time to be distributed because both donors have passed, right?
Right.
Okay. And then there's still the realty trust, and I assume Jonathan's still living in the property?
Yes.
So that's not ready. It's premature to do anything with that. He's got a life estate there.
He's got a limited life estate. If he was to move,
right,
he loses the property. If he was to sell it, he loses. He has to split the way it was drawn up.
And then there's more. There's something else in the.
The extrinsic evidence, Your Honor, I think the family trust would be whatever was left.
Okay.
Okay. And there, I mean, it says any amendment.
And then that thing gets divided into three more trusts.
Yeah. It's a complicated, comprehensive estate plan. There's no question. But I mean, in that family trust, it says any change needs to be signed by both of us.
Right. No, I understand, but no, we can't really look at that in terms of the summary judgment.
No. It's just a matter of we're trying to show what their thoughts were at the time they created these plans.
One more thing. So you have your undue influence claim is dismissed, so you could have this appeal, but you've got a tolling agreement. So after this is decided, you can go. If you lose here, you can go back and still argue undue influence.
Correct. That was the decision. That was the decision we came to with my brother counsel, who's not here, to get this before you. So we had to have a way to get, and we can go back to that if we have to. But
okay.
Thank you. Thank you for your time. Appreciate it.
With that, the proceedings have come to a conclusion. I'd like to thank my colleagues, the court staff, court officers, our clerk's office, our law clerks, and the excellent timekeeper. And we will stand in recess.